The courts are helpless. That chilling sentence, whispered by a former federal appellate judge to CNN, sums up the quiet earthquake now rattling the American judiciary. 6 months into Donald Trump's second term, the White House isn't just pushing legal boundaries, it's bulldozing them. Court orders are ignored, judges are sued en masse, and the Constitution itself feels like it's hanging by a thread. But here's where it gets controversial. Some legal scholars argue the judges are partly to blame for their own predicament. Could the judiciary's centuries-old tradition of restraint now be its Achilles heel? Let's unpack what's happening, why it matters, and crucially, what could come next. 1. A summer of shockwaves. Imagine waking up to discover the entire federal district court in Maryland has been named as a defendant in a lawsuit filed by the U.S. Department of Justice. That's exactly what occurred in July 2025, the administration's grievance. Chief Judge James Boasberg had dared to pause deportations until each migrant's due process rights were verified. Rather than appeal through normal channels, the DOJ took the unprecedented step of hauling every judge on that court into court, an action one veteran litigator called the legal equivalent of carpet bombing. 2. Judge Boasberg in the crosshairs. Chief Judge James Jeb Boasberg of the powerful D.C. District Court has become the administration's favorite judicial punching bag. After Boasberg ordered planes carrying deportees to El Salvador to turn around, citing lack of due process, the DOJ retaliated with a formal misconduct complaint. Their accusation? Boasberg had privately warned Chief Justice John Roberts that the administration might trigger a constitutional crisis by ignoring court orders. The DOJ claims this conversation proves bias. Boasberg's defenders call it responsible judicial foresight. Who's right? The answer could redefine judicial independence for a generation. The contempt saga that fizzled. 3.5 months ago, Boasberg launched a criminal contempt probe against administration officials he believed had misled him. On Friday, a federal appeals court led by 2 Trump appointees slammed the brakes. Their reasoning? Allowing the probe to continue might escalate an already dangerous standoff. Translation? The judiciary blinked first. Critics say the ruling telegraphs a green light for future defiance. Supporters insist it prevents an outright constitutional meltdown. Which side do you fall on? 4. Why judges feel handcuffed. Courts have potent tools: contempt citations, fines, referrals to bar associations, but they rely on the executive branch to enforce them. When the White House controls the very marshals who might haul a defiant official to jail, the balance of power tilts dramatically. One retired judge put it bluntly: "We can issue orders until we're blue in the face. If no one carries them out, we're just publishing expensive PDFs." 5. The slow-motion contempt case in Maryland. Back in Maryland, a Venezuelan man was whisked to El Salvador in March, again without a hearing. His lawyers told a judge Friday they're still deciding whether to seek contempt charges. 5 months of deciding. Legal scholars note that hesitation is itself a symptom of judicial paralysis. Judges fear that aggressive sanctions could provoke even bolder executive defiance, yet inaction invites more lawlessness. 6. Trump-appointed judges, friend or foe? Conventional wisdom says Trump's own judges will rubber stamp his agenda. Reality is messier. Judge Mary McElroy, a Trump pick in Rhode Island, recently scolded HUD for sitting on $760 million in court-ordered housing grants. Meanwhile, the Supreme Court's conservative majority has largely greenlit Trump's emergency powers, but individual justices have signaled limits. The takeaway? Even loyal appointees bristle when the rule of law is openly mocked. 7. The whistleblower who lit the fuse. In late June, A career DOJ attorney accused top official Emil Bove of urging lawyers to ignore court orders and, allegedly, to tell judges, "Fuck you." Bove, now a freshly confirmed appellate judge, claims amnesia. The episode underscores a toxic culture some say is seeping into the Justice Department itself. When attorneys are encouraged to treat judges as obstacles rather than co-equal guardians of the Constitution, the entire system wobbles. 8. Are we in a constitutional crisis yet? Ask 10 judges, get 10 answers. One D.C. Circuit veteran told CNN we're in the incipient stages, not a full-blown crisis, but a slow-motion unraveling. The tipping point, they say, would be outright defiance of a Supreme Court order. That hasn't happened yet. Still, every ignored subpoena, historical echoes, and future flashpoints. Conservative icon Judge J. Harvey Wilkinson III recently invoked President Eisenhower's enforcement of Brown versus Board of Education as a reminder that executive respect for the courts isn't partisan, it's foundational. Wilkinson warned that if the branches grind irrevocably against one another, history will record not just a constitutional failure, but a moral one. 10. Your turn. Where should the line be? Here's the controversy most commentators dance around. Should judges fight fire with fire, jailing officials, freezing White House bank accounts, unleashing every coercive tool in their arsenal? Or does restraint preserve the judiciary's fragile legitimacy, even at the cost of short-term compliance? Drop your take below. Is aggressive judicial pushback the only path to survival, or would it trigger an even darker constitutional showdown? One thing is certain. The courts are no longer the quiet, marble-columned referee of American democracy. They're now a frontline battleground, and the next move, whether from a judge, a president, or an outraged public, could redraw the boundaries of power for generations.